Hello, everyone, and welcome to Uncivil Law. I hope you're having the greatest day as always, and we are here with the latest update in the Vic Mignogna case, which we have covered several times on this channel. And I have potentially good news for the Vic fans, but it does come with some caveats. But I'm going to say give you some hope. There's some hope because this brief that was filed by Nick is actually very, very good and highlights the most critical legal issue, I think. There may be some problems from some technical perspectives. We'll get to that in the end. But there's reason to hope. I've gotten lots of criticism from the Vic supporters who think I'm just being very mean to them and mean to their side. I don't mean to be. I try to give an even and fair analysis and just try to give the legal impression based on what I see. I don't have anything in favor of him. I don't have anything against him. Just trying to call it like I see it. So I'm calling this in favor of Vic's side, and so that's because that's what I think it is. But there's some technical caveats. So for those of you who may have forgotten what the Vic Mignogna saga was about, or you're here for the first time for some reason, well, let's talk about Vic Mignogna. Vic Mignogna was a voiceover artist. He did characters such as Broly in Dragon Ball, which was one of his more notable roles, perhaps. And he got Me Too'd. He got Me Too'd by his fellow voiceover artists at Funimation, where he was a contractor. And he got accused of some things that don't really seem like problematic at all and just kind of joking, and then some stuff that was more problematic, but it was all really long ago and really in the past. And maybe one time he gave someone a hug when he didn't want to. Maybe one time he ate a jelly bean as a joke. I don't know, but he got Me Too'd and he got fired as a result. So super fun times. Then a bunch of people said some very mean things about him online. So, and then also his attendance at various conventions dropped off dramatically as people didn't want to associate with him. So he sued in Texas for defamation and for tortious interference, for interfering with his contracts. Then the other side filed the Texas Citizen Protection Act, or Participation Act. I can never quite remember what the P stands for. Not that it matters. It's the anti-SLAPP in Texas, which basically says, oh, you're trying to limit our free speech. Judge granted it. Vic lost, ruled against Vic for about $500,000, and now we're on appeal. That's the short summary of all that stuff. So yeah. So we have covered in the past. We covered the initial filing. We covered the response. We covered the TCPA. We covered the response. We covered the oral argument hearing on the TCPA. We covered Vic's brief, and we covered all the reply briefs, all three of them. So I think there's 10 videos we've done on this subject already, and I think this will be 11. And we're going to cover Nick Rekieta's brief as an amicus, as a friend of the court. So we're going to discuss that and see what it has to do. Okay. So we will discuss that and see what he has to say. So let's do that. This is Nick's case. Or Nick's brief. Apologize. It's not Nick's case. He's an amicus. He's not representing a party. And we are going to just kind of discuss it and see what he has to say and what arguments he says and how it changes the outlook. As you may remember, when we last left the action, I was giving Funimation 90% chance to win. Let's see if the odds change because of what Nick has written. I'm going to do that all day. I just know I am. I'm going to confuse Nick with Vic. There's just no chance I'm going to get it right. We'll do our best, but let's see if it changes for Vic based on what Nick wrote. All right, let's give that a shot. Okay. So then we have, table of contents, tables of authorities, statement of interest. I am just an amici. I have no particular interest other than I'm trying to be a friend of the court. That's always a good thing. Let me see if I can make the border a little wider. Yes, I can. Yeah, it's a little better. A little less cramped. Okay, so let's start at the top. The Texas Citizen Participation Act, which is the anti-SLAPP, anti-strategic lawsuit against public participation. You are suing me merely to prevent me from speaking my truth. That's what this is. Popularly and commonly serves as a bulwark against malicious and frivolous litigation designed to stifle free speech and public participation. That is fundamentally its goal. However, nested in the same purpose statement of the Texas Civil Practices and Remedies section is an important and oft overlooked command: protect the rights of a person to file meritorious lawsuits for demonstrable injury. Yeah, If it's demonstrably meritorious, it should go forward. If not, then not. Okay. This case is meritorious. Now, it might have been at some point, but yeah. The appellant has demonstrated injury. In fact, the pleadings, motions, and submitted affidavits of all parties are replete with examples of injury and what caused it. Fair enough. The appellant establishes the facts of when, where, and what was said, the defamation nature of the statements, and how they damaged the plaintiff. The decision of the district court should be overturned and the case remanded for further proceedings. All right. Importantly, there's a legal question surrounding the live pleading and accompanying evidence that must be resolved. And this is where I think Ty Beard, who does represent Vic, screwed the pooch. And Nick is over here trying to save the day for Ty because he's trying to bring attention to what is, by far and away, Vic's best argument. Not well developed by Ty, but Nick is well developing it. He's actually going to the heart of the best issue, in my opinion. So then he says, according to the rules of civil procedure and the relevant case law, the appellant's second amended petition, which is not struck, should be live and the operative pleading, but the trial court chose not to consider it. This is prejudicial not only to applicant, but also any future plaintiff subject to the TCPA motion to dismiss. Yeah, that's kind of where the ball game on this is, in my humble opinion. This is the ball game, or at least a very big part of it. So there was an initial pleading. There was an initial pleading which was very bare bones and very basic, as you have a right to do. You just give a notice pleading. And then the TCPA shield went into effect. And then Ty Beard attempted to file the second amended, because you get one for free, incidentally. He tried to file the second amended. The first amendment didn't really do anything. The second amended, he tried to file like right before the hearing. He filed it, I don't remember how close, but it was within 7 days. And there's a rule dealing with trials, which may be the same thing for hearings, that says, if it's within 7 days, the court can deny it if it's surprise and so forth and so on. But the court never actually struck it from the record. They said we take it up later, and then then at the very end of the case then they treated it like it didn't exist. And then at the very end of the case said, well, we're denying all of their motions that might be pending, which includes the motion to strike the amended petition, right? Because one of the motions was the motion to strike, which was still pending because the court never ruled on it. And the court said, well, we're denying all outstanding motions, which also includes the motion to strike, which was still pending. So that means the Second Amendment must be still operative because the motion to strike was never granted. Therefore, the court committed reversible error by failing to consider it. That's a pretty good argument, Nick. Kind of wish Ty had made that argument, but yeah, okay, that's good. Complicating the issue with the second amended petition is the improper construing of the parties' Rule 11 agreement. I think this is a very fair point, too. A trial court extended the scope of the Rule 11 agreement beyond the direct meaning of the language. Good point. Future litigants must have faith in the court's ability to properly read and enforce. Personally, I would have dropped the read because it's a little bit much. Just enforce would have been fine, but read and enforce is a little bit much, but whatever. In this brief, CR refers to the clerk's record, and RR refers to the reporter's record, things that are in the record. Very super promising. Internet commentator says, wasn't the Second Amendment complaint past the deadline, though? Quite possibly it might be past the deadline, but the court never actually struck it. So there is a issue there to be resolved, which was never really resolved, but we'll get more to that at the end, but thanks for the question. The issues presented. The parties have filed substantial briefs covering multiple issues. This amicus will only cover one issue. Did the lower court err in excluding the Second Amendment petition and other evidence for the purposes of the Texas Citizens Protection Act? Statement of facts. So he's going to review the facts that I just kind of summarized at the beginning, but we'll read them anyway. Appellant Vic Mignogna, as well as the appellant Jamie Marchi and Monica Real, are voice actors who give English dubs to Japanese characters. Appellee Funimation Productions is the American distributor of Japanese cartoons and other merchandise who employ Vic, Jamie, and Monica. Appellee Ron Toy is allegedly engaged to Monica Real, but otherwise not apparently relevant to the English dubbing industry. Starting in January of 2019, the appellees, Real, Toy, and Marchi began a smear campaign, accusing appellant of various criminal acts, such as assault, harassment, and sexual assault, as well as other sexual and professional misconduct. A slightly charged, if not fair. So again, This is written in slightly charged language, which is fine. It can be written in charged language, but it's a fair characterization if a little bit charged. In February, appellee Funimation made a series of 3 tweets about their termination of Vic Mignogna following the investigation. The gist of these tweets was understood by the readers of Ordinary Intelligence and the appellee raw as proof that appellant was terminated due to sexual misconduct and harassment. I think that's very, very fair. Yeah, I agree. I agreed with that before, too. I thought that was a fair point. Now, there are still issues of like public figure and some other problems, but I did agree that you would read it as being related to Vic. So, yes. Appellee Toy leveraged his alleged relationship with Rial to claim inside knowledge of the allegations and investigation and tweeted hundreds of accusations of sexual misconduct and sexual crimes about the appellant. Okay. On January 20th, the appellant unequivocally stated, any allegations of sexual harassment, sexual assault, and most disturbingly, assault against minors are completely and utterly false. Appellees Rial and Toy would proceed to contact the convention, Comic-Con, and repeat the accusations to the conventioner, Chris Slatosh. So this is the tortious interference. Tortious interference summarized very briefly. Party A and Party B have a contract. Party C now comes in and starts spreading lies, for example, about Party A or Party B. As a result of that, the parties cancel the contract. That is tortious interference. You were not part of this deal. Now you've injected yourself. You're telling lies. That's the tort. And it caused harm, the contract being canceled. So if that were true, that they contacted the conventioners, that might very well be tortious interference. Toy and Rial threatened that if Slatosh did not cancel appellant's appearance at the convention, they would withhold his sponsorship, and Rial would breach her apparent contract and convince others to breach their contracts as well. Oh, okay. Slatosh did eventually cancel the appellant's appearance due to the actions of the appellee. Slatosh would eventually re-invite applicant after considerable expense and under new contract terms that were unfavorable to applicants. So this is trying to insert the issue of the damages, because this was a point by the judge. You did go to the convention, right? And so there's like no damages, so no harm, no foul. And Nick is saying, well, there is a harm. The terms were less favorable, so that's a harm. Fair enough. Appellee Rial would go to cancel her appearance as promised and induce other attendees to do the same. Through the course of the smear campaign by the appellees, appellant would have 12 convention appearances contract canceled. The existing record clearly established what was said by whom, where, and when they said it, as well as the resulting damages. KVLT 1349 in chat says you don't need to have said lies in order to be something for it to be TI. I didn't say you needed to be lies. It was an example. I was providing an example. I wasn't saying this is what TI is. I was saying an example of here's a thing that would be TI. Other things might be TI too. So, okay. The procedural history. The procedural history in this case is voluminous, and the brief will focus only on the relevant aspects leading up to the TCPA hearing and through the final judgment. On July the 1st, 2019, Appellee Funimation would file its motion to dismiss under the TCPA. The appellees, Marchi, Rial, and Toy would file similar motions to dismiss on July 19th. Appellant and appellees would file competing motions to strike, none of which would be ultimately granted by the court. That's an important detail on the procedural aspect as to what remains pending was not. The motion was never granted, therefore it remains pending, therefore it's operative, therefore the court was in abuse of discretion not to consider it. Yeah. Importantly, the parties would enter a Rule 11 agreement on August 6, 2019 regarding a continuance of the TCPA hearing and timetable for motions and objections to TCPA for all parties involved prior to the hearing. Appellant agreed as follows. Plaintiff will file his responses to the TCPA motions and any objections to motions to strike on or before August 30th, 2019. Appellees agreed their replies and any evidentiary objections would be filed on or before September 3rd, 2019, and the hearing was moved to September 6, 2019. Appellee encountered technical difficulties and filed a response to the TCPA just after midnight on August 31st, 2019. They would request leave of the court for the late filing, and the court determined that the response was timely filed. Appellant filed a second amended petition on September the 3rd, 2019. So this is the really big deal here, this second amendment petition. The court heard arguments over the Second Amendment petition at the September 6, 2019 hearing at the motion to strike. The court did not rule on the motion to strike at the hearing, said, "I'll deal with that later." But they wouldn't, leading to the problem. The hearing proceeded on the first amended petition, with the court saying, "They're not using that one. You're using the old one for this hearing." Okay. So, was that like a ruling? Well, probably not really explicit. In the October 4th, 2019 order granting the TCPA motion, the court stated it did not consider evidence submitted after the agreed upon deadline in the Rule 11 agreement. The court has still not ruled on the motion in the strike the Second Amendment petition. So there's the first potential thing. If you're saying did not consider evidence, is that the same thing as saying the motion to strike was granted? Could the Court of Appeals read it that way? Could they read it as, not in word, but in fact, that the court granted the motion to strike without actually saying it? That's possible. The appellant filed this notice of appeal on October 24th, 2019. Finally, on November the 25th, 2019, the court issued its final judgment, closing with the statement, "All other relief requested and not expressly granted herein is hereby denied. For example, the motion to strike." Good. This judgment finally disposes of all parties and claims and is appealable. Despite multiple motions to strike and objections before the evidence, the court never ruled to strike or sustain any objection to the evidence submitted by any party. That's a very fair characterization of the history of this. You could read certain things the court did as granting the motion, but court never said it explicitly. So, that's a very fair point. The court failure to consider the Second Amendment petition without striking is a reversible error. Fair. The court's improper application of Rule 11 agreement precluded evidence without striking said evidence and was reversible error. Fair. The court's refusal to consider clear and specific evidence and resolve factual matters in favor of applicant is a reversible error. The Second Amended petition is a legally operative petition in this case. Yeah, might very well be. The court correctly states that if I don't strike the Second Amended petition, then we're going forward on the Second Amendment petition, so don't we have to deal with that first? The court failed to strike the Second Amendment petition, but proceeded with the TCPA hearing on the First Amended petition in violation of the rules of civil procedure. Yeah. In fact, the court expressly denied relief sought by the motion to strike. The Second Amendment is November 25th, the final judgment. Well, I don't know that I'd go that far. I mean, they didn't say, I'm denying the motion to strike. They said, I'm denying all pending motions, which, isn't really expressly. It's kind of implied, but, again, this is written with a certain flair, so it's fine. I'm analyzing this more on a, do I agree with it more than, is it good? So, yeah, this makes sense. I'd write this, but, on a purely factual level, no. The court improperly applied the August 6, 2019 agreement to preclude evidence in the Second Amendment petition despite the plain language of the rule. The rules agreement contains specific legal documents, appellant's responses to TCPA motions, appellant's objections and motions to strike, and evidentiary objections in support of the TCPA motion. The Rule 11 agreement does not contemplate amended pleadings or supplemental evidence. That's true. I mean, yeah, that's true. So the Rule 11 doesn't deal with amended things on its own terms. That's fair. So you'd have to look to some other rule for that. So it doesn't contemplate amended pleadings or supplemental evidence. The court is obligated to take a definite legal means within Rule 11 agreements and construe them as a matter of law. Yeah. So the Rule 11 agreement doesn't apply to this. So then the question is, what are the rules dealing with this generally in terms of what does have to be submitted and when, and was it submitted in time, and so forth and so on. So there's two potential things that are possible here. There's two potential things that are possible: a technical correction, which won't really matter, and a non-technical correction, which will matter quite a lot. So scenario number one is the Second Amended was not filed in compliance with the rules, all the rules. So that's, possibility number one. The Second Amendment petition was not filed in compliance with the rules. If that's true, the court's failure to strike itself is reversible error, incidentally. And so the Court of Appeals could send it back to say, hey, this wasn't submitted with compliance with the rules. You never ruled on the motion to strike, so please enter the motion to strike and, and dispose of all the issues. And so then, they'd presumably rule against him on every other ground, and the trial court would go back and enter the motion to strike and be done. So there's that technical win that won't really matter if the petition was filed not in compliance with the rules. If it was filed in compliance with the rules and the court never ruled on it, and in other words, then that's like a minimum abuse of discretion, because you had to at least consider it. And even if you would strike it for some other reason, like abuse of process or whatever, you have to actually go through that analysis. You can't just do it because it violates the rule. So if it's within the rules, you might be able to not consider it anyway if you found some reason to do that, but you didn't even go through that kind of analysis. So, we can't just, ignore that. You'd actually have to go and do the analysis, which you never did. So that's, more substantive. So go back and figure either A, consider the thing, or B, give us reasons why this was not entered for valid legal reasons, and go through the analysis and show us why that's good. So that would be very helpful if it's option B. So yeah, so that's part of what we're trying to figure out here. So here's the arguments and the authorities. All right, so what does the law teach us? It's always a good place to start. The applicant's second amended petition is a legally operative document, and failure to consider the Second Amendment is reversible error by the lower court. The Texas Rules of Civil Procedure, Rule 63, provides that parties may amend their pleadings, respond to pleadings on file of other parties, file suggestions of death and make representative parties, and file such other pleas as they may desire by filing such pleas with the clerk at such time as not to operate at surprise to the opposing party. So that's a potential basis to deny if it was surprise, provided that any pleadings, responses, or pleas offered for filing within 7 days of the date of trial or thereafter. Potential issue there. Is a hearing the same thing as a trial within the meaning of this rule? That's another issue. Or at such time as may be ordered by the judge under Rule 166, which my understanding is there wasn't that, so that doesn't apply at all, shall be filed only with leave of judges obtained, which leave shall be granted by the judge unless there's a showing that such finding will operate as a surprise to the opposing party, and you didn't do that analysis. So there's potential issues to be had here. Maybe you didn't show why it would be surprised. There's potential issues. Internet commentators, I think, since Nightbox heuristics are set too strictly. A sentence with 3 capital letters was considered all caps. Well, let me check. You are correct. I am. I don't think Nightbot did that. I think that was Streamlabs who did it silently. I think it's within their dirty words filter. I don't think, because if it was stricken for all caps by Nightbot would have told you. Oh, it did. It did say it was Nightbot. All caps are not permitted. Well, that's lame. There's not enough caps in that sentence for Nightbot to trip over. I'll have to figure that out later. Sorry. I don't know what the problem is. Yeah, I'm sorry. It shouldn't have done that. All right, let's press on. Texas Rules of Civil Procedure 65 states, unless the substitute instrument shall be set aside on exceptions, the instrument for which it is substituted shall no longer be regarded as part of the pleading and record of the cause unless some other error of court in deciding upon the necessity of the amendment or otherwise in superseding it be complained of, and exception be taken to the court, unless it be necessary to look at the superseded pleadings on a question of limitation. That's exactly what happened. You're 100% right. That's right. When you get timed out by the bot, it deletes all your comments within a certain time period. I don't know how far it goes back, but yeah, that's why it did it. It doesn't just delete the one comment, it deletes all the comments or something. So yeah, that's why that happened. Okay, that makes a lot of sense. Don't do that. Appellant filed his second amended petition on September the 3rd, 2019. Appellees filed, among other things, a motion to strike appellant's second amended petition on September the 3rd, 2019. Quite simply, the trial court refused to strike the Second Amendment petition and further expressly denied the relief requested in the motion under the effect of its final judgment issued on November the 25th, 2019. It is clear from the plain language of Rule 65 and as well established in case law that the absence of being stricken a timely filed amended pleading is the operative instrument, and upon prior pleadings are not before the court. And the prior pleadings are not before the court. Appellees may argue, and indeed the trial court, that the petition was untimely filed under Rule 63. Good, very good for you. You got to try to figure out what your opponent's argument is and try to address it. Good deal. The validity of this argument will be addressed below. Good. But it's critical to restate that despite the argument made in the motion in open court, the trial court refused to rule in the motion or otherwise strike the Second Amendment petition at hearing, ordering the dismissal order, and ultimately denied striking the Second Amendment petition or any other evidence objected to by any party in the final judgment, stating all their relief granted is hereby is not, all other relief is denied. Okay. Briefly addressing the argument that the second amended petition was not timely filed under Rule 63. All right, let's give that a shot. Rule 63 allows an amendment without leave at any time, so long as it's not within 7 days of a trial or thereafter. Yeah. Rule 63 allows amendment by leave and directs further that leave should be granted unless there's a showing that such a filing will operate as a surprise to the opposing party. Rule 63 applies when there's a trial on the merits of the case. And then he says, citing something that's going to be very, very important, a TCPA motion to dismiss is not a trial on the merits, is not intended to replace either a trial or summary judgment proceeding. So like so Rule 63 he cites, so we'll read these footnotes because this is going to be really, really important. So he says the Rule 63 applies when there's a trial on the merits, and so that's case law 1. And then he says case law 2, a TCPA motion is not a trial on the merits. So therefore Rule 63A doesn't apply, is the argument. And then he cites some footnotes, which is always super helpful. And he cites, for the proposition that Rule 63 applies when there's a trial on the merits, he cites this case from the Texas appeal of Fort Worth, which is the court we're in. Excellent. So that's precedential authority from the court that we're in. It's precedential authority. That's the Court of Appeals we're in. Way to go. So that makes it binding legal authority. Excellent. And then he cites this other thing, which was reversed on other grounds by this other case. So he says, I have precedent that stands for this proposition. Very good, Nick. Good job. So for the precedent for a TCPA motion is not a motion to dismiss, or it's not a trial on the merits, he cites Stalin-Ollerfield, which is a case in Texas Appeal Easterlin, petition denied. Texas Appeal Dallas, petition denied. Texas Appeal Eastland. Persuasive authority, not binding authority. Wrong courts. So then the issue, okay, let's back up one step. First, we have 3 different courts of appeals. Because we have 2 actually. We have Eastland and Dallas. So we have 2 different courts of appeal that say a TCPA motion is not a trial on the merits. So, but not from this court. So that makes it persuasive authority, not binding. That being the case, you do have 2 of them, and it's at least persuasive. So if the trial court is going to go the other way, or the Court of Appeals is going to go the other way on this, they have to have a reasoned decision that they think it is, and, okay, that sounds promising. Sounds like a promising legal argument. All right. This court held in Grand Prairie that Rule 63 does not apply to the matter of preliminary to a trial on the merits. Rule 63, okay, is that the one he cited from above? Yes. So then he says, the court held in Grand Prairie, Rule 63 does not apply to a matter preliminary to a trial on the merits. That's certainly suggestive of the TCPA, which is binding legal authority, because we're in the right circuit on that one. So that's suggestive. It should hold similarly here when a TCPA motion to dismiss cannot by its function be a trial on the merits. Yeah, that's a pretty persuasive legal argument, Nick. Good job. It should similarly be emphasized that although appellees raised the issue of surprise in their motion to strike and in open court, the trial court did not strike the Second Amendment petition at all, nor did it mention the Rule 63 or surprise anywhere in its decision to not consider the live pleading. You didn't do the analysis. That's a bad. You didn't do the analysis. That's a bad. The probability of this getting reversed has increased dramatically from the 90% Funimation is going to win and 10% to reverse. The 10% number has increased. How much? Well, we'll get to that later. All right. Rather, the trial court cited the Rule 11 agreement as the impetus to ignore the live pleading and submitted evidence, which, was not within the terms of the Rule 11 agreement the way Nick reads it, and I have to agree with Nick. That's not the way I read it either. Good point. Then he goes to this ultimate issue, just to throw some words in on that. The ultimate issue of, well, was it surprise? Well, let's discuss that for a little while. Surprise in this case would similarly not be applicable. The Second Amendment petition offers no new causes of action, nor did it introduce new parties. The district court mentions new evidence attached to the Second Amendment, but those were unsworn declarations replacing the withdrawal and defective affidavits. So it wasn't really new. Not bad. In fact, the record shows that appellees had already contemplated the original affidavits, which were substantially identical to the unsworn declarations meant to replace them. Surprise simply is not possible if they're already aware of the evidence. That's not a bad idea. Not a bad idea. Both appellees and the trial court misconstrued the Rule 11 agreement. Relying on it to ignore the live pleadings as well as submitted evidence was prejudicial to the appellant and is reversible error. It is reversible error, I agree. The trial court's adherence or failure to adhere to Rule 11 is reviewed under abuse of discretion standard. I think I might have mentioned this at some point earlier in the stream. Right, abuse of discretion. Did the trial court abuse its discretion by failing to consider it? Yeah. Abuse of discretion is a question of whether the court acted without reference to any guiding rules or principles. In this case, the district court went against the plain and definite language of the Rule 11 agreement and attempted to give the agreement a greater effect than the parties intended. Yeah, that's pretty persuasive. It can certainly be argued the district court attempted to follow a guiding rule or principle in its citation to a Texas Tech Law Review article. Okay. This, however, is a faulty argument. The article does not cite to any existing authority regarding amended pleadings following the filing of a TCPA motion. Rather, the article cites to a case concerning the Texas Medical Liability Act, a completely different statute, and the California anti-SLAPP decision. There's no existing case law or statute precluding the amendment of police proceedings subsequent to the filing of a TCPA motion to dismiss. Is there any case law that says exactly the opposite of that? That would be really helpful, but there's no citation in that. We sort of implied it from earlier because of the things about it, if they had something really explicit, that'd be a good time. So the trial court over here is saying, well, there's no authority that says I have the ability to deny this. I'm going to take notice of this law review article. And it says, well, here's a situation dealing with the Texas Medical Liability Act, which is a completely different statute, but might be informative here, to be fair to the court. And a California anti-SLAPP decision, which, again, although it's in California, might be informative here. So was the trial court wrong to say, well, I'm going to take note of these informative things and create completely new case law? Which, someone has to create new case law. That's how these things happen. Someone somewhere has to be the first. So did the Texas court do a bad by creating new case law based on this, especially in light of the authorities that was cited above dealing with this is not a trial on the merits? Did they do a bad? That's a good legal question. Good to raise it. There are existing rules surrounding the amended police proceedings, such as oh, sorry. Okay, I have to find where I was. I apologize. 1 second. Yeah. There are existing rules surrounding the amended pleadings, such as Rule 63, which is discussed more thoroughly above. Yeah, very, very fair point. And nice to bring it back. Bring it back. It's there are already... So can a trial court create rules out of thin air? Well, there are these existing rules that already exist, and I already told you about it, but I'm going to remind you. Nice touch. I like that. Very good. Rule 11 agreements are contracts relating to litigation, and the court construes them under the same rules as contract. Yeah, agreement between the parties is essentially contract, right? The instant Rule 11 agreement, the one that is operative here, contains a specific set of agreements reproduced in their entirety. Okay, so here's what they actually agreed to in its entirety. Under Rule 11 of the Texas Rules of Civil Procedure, this will confirm our agreements regarding scheduling matters related to the motion to dismiss under the TCPA. The parties agree to the following. The plaintiff will file his responses to the TCPA motions and any objections, motions to strike on or before August 30th, 2019. Defendants will file their replies and any evidentiary objections in support of the TCPA motions and any objections to strike on or before September 3rd. Hearings for the motion to dismiss and any party's objections, motion to strike, to the extent the court deems that necessary, are set for September 6th, 2019. Plaintiff, and Funimation agree the 60-day TCPA hearing deadline for Funimation is extended to the 6th. Parties agree that the hearing on the motion to strike that's currently set for the 8th has been moved to September 6th as stated above. Yeah. The language of the agreement is clear and unambiguous. It's pretty good legal language. The Rule 11 agreement pertains to specific legal filings, with responses to the TCPA motion being pertinent to this analysis. Responses to the TCPA motion to dismiss are specific documents under the TCPA. Perfectly fair. In fact, a response to the TCPA is set aside from an amended pleading in their differing treatment under the rules. The TCPA does not contain a deadline to file a response to a motion to dismiss. In the absence of a rule, a trial court has discretion to determine the timeliness of a response. Yeah, so if it was TCPA, the TCPA does not itself contain deadlines, but if it were TCPA, you could consider timeliness if it were TCPA. But this isn't TCPA. This is in the regular world, not the TCPA world. So contrast this with Rule 63 governing amended pleadings, and we will have a different treatment for a clearly different legal document. Pretty good writing. I like this writing. It's very good. The court does not give a Rule 11 agreement greater effect than the parties intended. Yeah, like contract. All parties to the agreement are licensed veteran attorneys in the state of Texas. There's no reason to doubt the specific and precise meaning of the words used. In fact, the nature of this agreement was specifically negotiated by the parties via email and eventually a phone conference with the trial court on August the 1st. If a contract can be given a certain or definite legal meaning of interpretation, it is not ambiguous and we construe it as a matter of law. Perfectly fair. The district court cannot ignore definite legal meanings of responses to TCPA motions to dismiss. These responses are mentioned by statute. It has a specific meaning that's defined, and they have specific rules for implementation that differ from these amended pleadings. Yeah, that sounds right. The court's decision to expand the terms of the Rule 11 agreement to give it greater effect than the parties intended and the definite legal meanings were not construed as a matter of law. This is an abuse of discretion by the trial court. I agree. For the reasons stated above, the Second Amendment petition is the live pleading for the purposes of the TCPA, and the trial court erred in failing to consider it. The refusal to consider the Second Amended is prejudicial to the applicant and thwarts the court's ability to faithfully and dutifully execute the TCPA's purpose to protect the rights of people to file meritorious lawsuits for demonstrable injury. I like this, bringing it back to the very, very start. So he has this nice mirroring, very, very sharp. Very, very sharp. He's mirroring his intro in his conclusion, because he mentioned this in his intro, and now he's bringing it back. Very, very good. Very, very much respect. It bears repeating that the applicant has submitted 100 of defamatory statements that were made by appellees on Twitter and other electronic media with timestamps, many of them defamatory per se, unsubstantial allegations of misconduct as well as criminal act. Appellant has submitted the nature of damage done in his petitions and deposition. Appellant has been defamed by the appellees with specific allegations of assault and other criminal acts, all of which has been denied. Which gets into the issue of him being a limited purpose public figure and whether or not they were reckless to the truth, but, we can deal with that somewhere else maybe. Although I don't think it was particularly well developed by Ty in the argument against it. So this is probably not going to win as a basis, I would imagine, because it's mooted. It doesn't matter, in other words, if the Second Amended is the right petition or not. if it wouldn't come out differently. So it would make it moot. So if Vic is a limited purpose public figure, and I think that he is under the relevant law, then you need to show that they knowingly lied or had reckless disregard to the truth, which seems not possible based on the evidentiary record as far as I can tell, and certainly did not seem possible based on the legal arguments as developed by Ty, in my humble opinion. So, if it wouldn't matter if the Second Amended is on the record or not, because no amount of evidence would matter, because it just shows the level of defamation and doesn't particularly go to those other elements, then the Court of Appeals can ignore this issue completely and say, well, it's moot because you would have lost anyway. Which is totally a thing the Court of Appeals can definitely do, by the way. The Court of Appeals is like water on pavement. It will seek the lowest ground possible. It will do the easiest thing that is possible. They will not work any harder than they need to be. So if they can say it's moot, they're done. That's how courts work. The appellants establish the Lipsky fact against each appellee in each of the petitions. Appellant calls attention to the statement from Funimation in the original petition, First Amended and Second Amendment. These paragraphs from each petition are functionally identical. Appellant calls attention to the allegations of Jamie Marchi in his original petition, First Amended and Second Amended petition. Again, these paragraphs from each petition are functionally identical. Appellant calls attention to the allegations of Monica Rial in the original petition, First Amended and Second Amended. Monica's a guy? No, it should be her, right? Okay, well, whatever. Again, these paragraphs from each petition are functionally identical. Appellant calls attention to the allegations of Ronald Toy in his original petition, his First Amendment, Second Amendment. Again, these paragraphs from each petition are functionally identical. The notion that the appellees were in any way surprised by the Second Amendment is amended is absurd on its face, and each petition uses functionally identical language to describe the underlying allegations, all of which are factors similarly discussed in the depositions of the appellant and appellee, all of which were attached to the response to the TCPA motion to dismiss. The attached exhibits include statements of appellee Funimation, Monica Rial, and Ronald Toy. While statements of Jamie Marchi are not attached as exhibits, they were discussed explicitly in the deposition of Victor Mignogna. In fact, the deposition of Vic establishes the Lipsky fact for appellant Marchi alone. In the deposition, appellant not only identifies the statement, he denies the truthfulness of the statement and mentions the loss of convention appearance, citing specific statements as damages. Well, I don't know specifically on that. Appellee also describes the damage he suffered at the hands of all the defendants in the deposition. He describes the defamation story appellee Rial. It denies several facts in the story as defamation statement of Funimation. Well, that's saying the appellant believes it to be false, which you'd have to be in order to sue. So what Vic believes to be false is super interesting and all, but how does the appellee, how is that false? That's way more interesting. The record is replete with evidence of defamatory statements, who said them, when, where, and how they were posted, and the damage resulted from these statements. In the context of the defamation case, pleadings and evidence establish the facts of when, where, and what was said, the defamatory nature of the statement, and how they damaged the plaintiff should suffice to overcome a challenge to the TCPA. Appellant has clearly done so in this case. Applicant's Second Amendment petition and attached evidence was disregarded in error at the trial court level. The trial court also failed to properly construe the Rule 11 agreement in a manner that was prejudicial to the applicant, and cited as the sole reason the court chose to disregard but not strike the Second Amended petition and unsworn declarations. Disregarding the evidence of the applicant, evidence which is admitted in the record, as known by the appellees. Well, did they know it at the time they made the statements would be the interesting thing, and just because he said it doesn't mean that they were in disregard of the truth. Just because Vic says it's false, even if they knew about it at the time they said it, doesn't mean that they were like blatant disregard, because why would they believe him, particularly if they had witnessed things, and why were they like basically reckless in ignoring it? Reckless is kind of hard. It's not even clear they were negligent, to be quite honest, because they didn't really have a duty, so, but whatever. Dismissing the frivolous lawsuits while preserving meritorious lawsuits is the purpose of the TCPA. To uphold one end but not the other defeats its purpose. To ignore admitted evidence which shows a meritorious case similar defeats its purpose. For all these reasons above, the court should reverse the trial court on all dismissals and allow the case to proceed. In the alternative, this court should reverse and remand with the trial court to instructions to consider the second amended and included evidence, which sounds like a possible thing that might happen. Signed by our good friend Nick Rekieta. And then he gives the certificate of service and blah, blah, blah. Super great. Okay. So let's go over the problems that I alluded to in the intro. There are some problems here, as I alluded to in the intro. So I got all the Vic fans to be friendly with me, and now I'm probably going to take it away. Again, I don't have anything against the guy. I just try to give the best legal analysis I can. I'm about to give a legal analysis that are raising some problems. All right. So here are some potential problems. Problem number 1. Can Nick file this amicus? That's a potential problem. Nick is a lawyer, to be sure, but not in Texas. The operative rule, however, in the Texas Rules of Civil Procedure, or Texas Rules of Appellate Procedure, I looked it up incidentally, doesn't say explicitly by its own terms that an amicus has to be an attorney. It's kind of silent on the issue. That being the case, however, I mean, if you read the rule on its literal terms, it doesn't say, like, it could be literally anyone who can file an amicus. And I find that a bit hard to believe, that that's really what the rule means. I haven't looked into it, but I would be hard-pressed to imagine that the Texas courts would interpret that rule as saying literally anyone, including no one who has an education of any kind, can file an amicus in our court. Doesn't seem like the kind of thing they would rule. So while the rule itself doesn't say that you have to be a lawyer in Texas, which, he's not, so he's not a lawyer in the relevant court. While the rule doesn't say that, that's a problem, potentially. Do you have to be a lawyer to file an amicus? I don't know, but I guess we're going to find out on that. All right, problem number 2. This brief was filed on September the 28th. That's potentially a problem because the case was picked up by the Court of Appeals on September the 22nd. This brief was filed 6 days after the fact of when the Court of Appeals picked up the case. Again, the rule itself doesn't appear on its own terms to say that there is a date on which you must supply an amicus to. But again, interpreting their own rules, I find a little bit hard to believe that after the court picks it up is going to be allowed, because as Nick Rekieta himself pointed out, technically speaking, the Court of Appeals can render a decision anytime after it picks up the case. So it could have rendered a decision on the 22nd, which, not particularly likely. So you're trying to insert something after they've already begun their consideration and analysis. You're trying to enter something after they've already picked up the case. Somehow, I'm a little bit doubtful that the Court of Appeals will allow that. So, the rules do allow an amicus brief to be refused for good cause, and I guess we'll see whether or not that will happen or not. So he submitted it, it's on the record, but it may be refused for good cause. I guess we'll find out. So that's a potential problem. Potential problem number 3. Amicus briefs cannot raise new issues. They can't bring in new stuff. They are meant as a supplement to the stuff already submitted by the parties. And the reason for that should be fairly obvious. If you were allowed by an amicus to bring in new stuff, then the word limit by the parties would be abrogated, because then the parties would say, well, I'm only going to write about these issues, and I'm going to write about them extensively to my word limit, and then I'll just get a friendly amicus to submit a brief that just happens to cover the other issues. And what are the odds, right? So the Court of Appeals are kind of, not idiots, and they're not going to let you do that. So the issues have to be sufficiently well mentioned in the party's brief, and you can't bring up new stuff. So let's figure out whether or not Ty did that. Did Ty give Rekieta enough latitude to raise this issue at all? So let's discuss that for a second. This is Ty's brief. This is Ty's brief filed on behalf of Vic. Okay? And this is the section where Ty talks about this issue to some degree. The TCPA requires the trial court to consider the pleadings and supporting and opposing affidavits stating the facts on which liability or defense is based when determining whether legal action should be dismissed. However, the trial court refused to consider Vic's second amended petition because it was filed within 7 days of the hearing on the motion to dismiss. The trial court focused instead only on the amended petition and the response. A trial court's refusing to give the second amendment petition consideration constitutes a reversible error. Generally, a party may amend its pleadings freely, but any pleading filed within 7 days of the date of the court requires the trial court's permission, which shall be granted unless there's showing a surprise. Indeed, the trial court has no discretion to refuse the amendment unless the opposing party presents evidence of surprise and or the amendment asserts a new cause of action or defense and is thus prejudicial on its face, and the opposing party objects to the amendment, citing some relevant case law from the relevant court, always promising. The allegations and claims in Vic's second amended petition were the same as those of the original petition and in his amended petition. The facts stated in and the exhibits attached to Vic's second amendment petition were consistent with and complementary to those stated in and attached to the response to the appellee's motion to dismiss, belying any claim of surprise by appellees. Therefore, the trial court had no discretion to disregard the second amendment petition in conjunction with the response to the motion, and at this trial court, refusal to do so is reversible error. And that's everything that Ty had to say about this issue. Ty's response was little more than a page. It was a page and a paragraph discussing the entirety of this issue on whether or not the thing was properly filed. And as my understanding is, it's not like Ty didn't have more words. My understanding is he did have more words. He just didn't very well develop the issue. So here's the operative legal question, I suppose. Did Ty sufficiently develop the issue in a way that Nick can now amend? And there are a lot of things, at least in my humble opinion, that Nick raised that were not sufficiently preluded to in Ty's argument. This doesn't, in its entirety, feel like a supplement. It feels like raising completely new issues. So there is an issue here as to whether or not Ty, in what his page and a quarter worth of mentioning of this issue, gave Nick even the latitude to raise these issues for the first time. So that's problem number 3. And then problem number 4 is, does it matter? Rekieta? I can never, I am. Rekieta. I try to get it. Rekieta? I think I got it right. Anyways. So then there's issue number 4. Does it matter? That's issue number 4. Does it matter? Is the issue moot? And that's also a very big lingering problem here. On the defamation issue, the trial court has found that he is a limited purpose public figure. I think under the relevant case law, he is a relevant public figure. So you have to show that the defendants were not only negligent, which is the bare minimum standard, but you have to show either they knew it was false or they were in reckless disregard to the falsity of it. And that's a very high standard to meet. It's tough to meet that standard, to show that they knew, to show they were in reckless disregard. Merely because Vic says it's false doesn't strike me as quite enough to get to reckless. Oh, he says it's false. Well, of course he'd say it's false. He'll say anything. It's not quite reckless to disregard that. So, and at least in my humble opinion, there did not appear to be enough evidence offered to get to show that any of these parties had reckless disregard, particularly Funimation, because they did all the investigation and, as thorough or not as it might have been, it was informed by that investigation. So it wasn't reckless, it seems to me. So that's a problem. So the whole thing might be moot on that grounds. Then we get to the tortious interference. Now here, Ty does have a potential out because the court did seem to go on to the TCPA based on the First Amendment when they should have gone on the Second Amendment. So that seems to be the language here. So Ty, when the court said, what conventions did they interfere with? Ty's answers were less than encouraging. The court gave him a couple tries to what conventions did they interfere with, and Ty didn't seem to know. It was not super. It didn't really go very well. Ty didn't seem to really know what conventions they interfered with, and it's like, well, it's Comic-Con, and then the court said, but he went though, and so there wasn't really any harm. So, that didn't go super well. But there's a potential out because if they based it on the Second Amendment, then maybe he would have been able to introduce other things that would have gone to show tortious interference. So, because there were other declarations and affidavits and so forth and so on, that might have been helpful to his case. So you got that going for you. So, that's a toss-up. That's a toss-up whether the Court of Appeals thinks it would matter either way. Whether or not, if they had the Second Amendment, whether or not any of that stuff would have given enough evidence to show it to be meritorious within the TCPA, it's a toss-up. But it's possible. It's also possible not. So, given all that stuff, I think that the odds for Vic have increased. We previously predicted Vic to have a 10% chance of wins. So how shall we call it now on terms of this? We have to consider whether or not Nick is able to submit this, whether or not it was timely, whether or not Ty gave him an opening sufficient, and whether or not any of it matters in the end. So there's all that. So I think I'm going to bump this up. I think that there's certainly some grounds to go the other way now. They've made the cogent arguments that at least make sense. So if the Texas Court of Appeals considers it, then I will give Vic a 30% chance to win. There's a lot here that the court could use to reverse it. The mootness issue is going to still be a problem because Ty didn't really develop it, although the Court of Appeals might give him an out because they were arguing on the wrong petition. So that's totally a thing that could happen. I've seen courts of appeals wave away less, though. And again, it wasn't particularly developed by Ty in his argument, in my humble opinion, that was the problem. He didn't say, at least to me, in the way I read it, by the way, we were arguing on the wrong petition. So that's part of the reason the trial court came to the wrong conclusion. Didn't really see that argument particularly well developed. So I will continue to give Funimation a 70% chance to win. So if it's considered, and I guess we'll find out whether or not it's stricken down by the court any day. But that's where we're sitting right now. I think this is by far and away the best thing that Vic has had on his side up to this point. I was not particularly impressed, as everyone well knows, with Ty's pleadings. I was somewhat impressed with Funimation et al.'s pleadings. This is by far and away the best thing that Vic has going for him at this point. So there's that. There are some problems, but you never know. You could get lucky. So there you go. Yeah. Oh, there's four reasons to reject this. 4 reasons to reject this. Because internet commentators said there are 4 reasons to reject this. The 4 reasons to reject this are: it wasn't filed by a licensed attorney in Texas. It was filed too late. Ty didn't give enough opening for this to be validly considered, and it doesn't matter mootness. So there's 4 different problems here. So, we'll see how any of that goes. But yeah. Yeah, there's. So this is a lot better. I'll do a couple comments on the chat just to finish out because I want to. Let's see what we say. Does Nick the lawyer know Vic on a personal level? I believe they've met. I could be mistaken, but I believe Nick has met Vic. I believe they've been at conventions together. Someone will have to double check me on that, but I believe they have met. I think they might have been on a panel together on a convention. I think that might have been a thing that happened. So they might know each other to the degree to which, they really know each other, but, whether or not, I think that they have met. Nick Rekieta does have a YouTube channel. However, he pronounces his name Rekieta, I think is right, but he'll tell me later, I suppose. The rule isn't plain language then. As everything, it's always informed by precedent and also other considerations, so that's kind of what's going on there. Nick pronounced it more like Rekieta. I've never actually talked to the man, so I've texted him, but I've never actually talked to him. So when I talk to him, I'll ask him how to pronounce his name, and hopefully I'll get it right after that point. Rekieta. Doesn't he have some kind of standing as a Texas business owner? Nick isn't a Texas business owner. He doesn't have business in Texas. His business is in Minnesota. Can a judge call a witness? I think it's possible, but it's very, very rare if it ever happens. And Marchie is Markey. Okay. Noted. Wouldn't Nick have some kind of standing since he's mentioned in the case? No, that's definitely not enough for standing. Is the Texas rule essentially a pro hoc vici framework? Pro hoc vici allows you to be a lawyer in the case. He's not a lawyer in the case, no matter what he's doing. So this isn't pro hoc vici. Pro hoc vici would be if you're a lawyer in the case, which he's not. He's a friendly party to the court, which it may have had to been signed off by a Texas local attorney. So, yeah. They tried to notice Nick for deposition. They got noticed and they would notice him. It got weird and stupid. I don't know why you would notice Nick. That seemed like a very strange thing to do. They wanted to dox him and failed. They got the address wrong. That's funny. Vic's problem is possibly being laid on procedural grounds. Yeah. Just tuning in, what is the Nick Rekieta brief? The Nick Rekieta brief is a friend of the court brief in the Vic Mignogna case. The Vic Mignogna case is a dumpster fire. Hopefully that's helpful. Oh, is Media Corp is based in Texas? I did not know that. That still wouldn't give him standing in this case. I mean, if he were involved as a party, that would certainly give him standing because, his case is in Texas. But just because he has a Texas business wouldn't give him standing in this case. He doesn't have standing in this case. He's not a party, nor can he be. He's just an amicus. So the fact that he's a Texas-based business, I don't think does anything for him. Rekieta. Got it, low. Thank you. All right. How do I rate this as legal writing? Solid. It's very, very good. On a scale of 1 to 10, I'd give it about an 8, 8.5. Solid. Well written. Well footnoted. Well argued. Very good. What is a greater dumpster fire? This or Sullivan Flynn? Oof. What is a bigger dumpster fire? I mean, it would be hard not to be Flynn, wouldn't it? I mean, Flynn is just epic dumpster fire. This is dumpster fire that is very, very local and affects an anime community that while very engaged is relatively small in the grand scheme. I think, and I could be mistaken, but I think on the conference call yesterday with the court for the Flynn thing, I think there were 8 different lines you could call into, and all 8 of them had 500 participants, and all of them were full. There were 4,000 people listening on that call. I think the Flynn is a bigger fire. Also, unlike the Flynn case, I think this case will eventually end. There will be an end to this case. It will eventually end. Unlike the Flynn case, which will never, ever, ever die. Yeah. Okay, well, we're done. We've reached all the chats and we've gone for an hour. So hopefully this was helpful. So Nick, I thought, raised a really good brief. There are a couple problems here, but, pretty good all the way. Michael Onis says the reckless disregard covers facts known by two parties and in disagreement. Nick reviewed the case law that Texas that shows that. That can't possibly be true. It can't possibly be true that merely because two parties agree, that in and of itself is per se recklessness. That can't possibly be correct. So if you say something that I disagree with, so I want to say something, and merely because you say the opposite, it makes it reckless disregard for me? That can't possibly be true. No way. Yeah, that can't possibly be correct. Just because, because you always, just think about the logic of it. Just think about the pure logic of it, all right? Think about the pure logic of that, if that were true. Think about the pure logic of it. If that were true, that would mean that if party A says a thing and party B says not a thing, literally no one else can offer a comment on it. Because if no matter whether you say A or not A, well, one of the parties has told you the exact opposite of that thing, right? So party A says A, party B says not A. What's party C to do? Under that interpretation where it was be per se because one person has said the exact opposite, party C literally can't say anything because, well, now they have actual knowledge that someone says the exact opposite of that thing no matter which way they go. And that would be a complete infringement to free speech. Party A, it would prevent me from talking about it, for example. That would prevent, okay. The pure logic of that would prevent me from doing this video. Nick says this is false. Funimation et al. Says it's true. Well, now I have actual knowledge that it's both false and true. So if merely making a statement that is in opposition to what someone else says is enough, then I have massive legal problems for offering opinion and analysis because, well, I have one party that says this is true and one party that says it's not true. So there's no possible way that can be true. It doesn't make any sense. It would inhibit Nick himself from talking about the case. Nick isn't a party to the case. And Nick is certainly even more well aware than me that one person says true and one person says false. So Nick can't comment on the case either. Apparently Nick over here has been guilty of reckless disregard of the truth this entire time. Does that sound like a thing that makes sense to you? Yeah, no. That doesn't make any sense. Yeah. No. Yeah, someone definitely broke me because someone offered some crap. What was the crap? It was from Michael Onis, who got me started on this, who said, quote, the reckless disregard covers facts known by two parties and in disagreement. Well, in a potential lawsuit between me and take your pick of Vic or Funimation, I would be a party. Right? So let's say Funimation or Vic want to sue me. Well, suddenly I'm a party. And apparently I've been making statements in reckless disregard because I know of facts that the other side says isn't true. Apparently I've been opening myself up to massive torts this entire time because in a potential suit between me, if Funimation or Vic wants to sue me, and I'm now a party, well, I've been making statements in reckless disregard to at least one of them this entire time because I knew for a fact they said it was true or not true depending on what it was at the time. Does that sound like a thing that makes any sense? Rekieta's liability is immense. We're all hosed. Woo! That can't be any sense. Oh, oh man. 2 people in a room? Yeah, no, well, yeah, I'll have to go with that. All right, well. Anyways, I'm going to sign off for now. If you like this stream, please give it a like. If you've not already subscribed, please give a sub. If you have not already hit the join button for 99 cents a month. You too can become an uncivilian and join me on my Discord and be my friend and all the rest of it. I hope this was helpful. I hope you enjoyed it. Until later, my friends. Cheers and goodbye.